Mr. Speaker.
My Lords, my Ladies, I appear on behalf of the appellants, who are the defendants. My learned friends, Mr. Ulrich Skerritt and Miss Thalia Francis Brooks, appear for the respondents, who are the claimants in the action. This appeal from Trinidad and Tobago raises an important point of defamation law, and one that has been uncertain for many years. It is whether, and if so in what circumstances, a claimant who is not named in a defamatory publication can rely upon facts that come to the attention of publishees after publication to prove that he is the unnamed individual referred to, and to complete an established cause of action. If he can, what is the principal basis for an exception to what is the general rule? The uncertainty as to whether a subsequent article are admissible was brought into sharp focus by what Mr. Justice Eadie described in Chase and News Group newspapers as the obvious tension between decisions of the England and Wales Court of Appeal in 1981, on which Lord Denning sat in both, Grappelli and Derek Block, and Hayward and Thompson. The Irish Supreme Court in 2011 described a great confusion has arisen as a result of the two cases. In Chase, Mr. Justice Eadie said that if subsequent facts could be relied upon, then it was in rare circumstances, and that the boundaries of the Hayward and Thompson decision are unclear. And his lordship said that whilst it's not always possible to foresee the circumstances which will come before the court, what matters is the principle, but the principle is not clear. Indeed, in the latest case on this line of authorities, the New South Wales Court of Appeal decision of Fairfax and Pedavali, they were contending for a much looser test, that it was always a question of fact and degree. The issue is not only one of legal interest, but is of practical and real importance to all who disseminate information to the public, not only commercial publishers such as the media, but individuals who post on social media, but also, for instance, a police service that is often informing the public about arrests without naming people, without naming the suspect. And it's important to pre-publication lawyers having to consider whether to approve an article for publication, what they have to foresee or try to foresee might be the situation in the future. If the law is, as found by the Court of Appeal here, then a publisher who takes care to release a report but not to name an individual could find themselves liable for that publication not hours or days later, but many weeks, or as in this situation, months later. And that can have a very real chilling effect on a decision to publish. The respondents here accept that the cause of action was not complete until they were named 6 or 7 months later in the subsequent publications. And even then, they didn't identify anyone who linked the articles and who gave evidence to say that they were the individuals referred to. And so on the facts of this case, for instance, would a newspaper publisher in my client's position decide to report on inquest proceedings if they thought that the reports could be relied upon, even exculpatory reports vindicating the claimants, to found a libel action in respect of articles published 6 or 7 months earlier?
Well, I mean, it's not my sort of area of the law, but I mean, publication, is that simply the original when the newspaper was put out? I mean, nowadays, publications stay on, available to read on the internet for months and years, but they're only published once, is that right? My
Lord, whether the internet calls for a change as to how the common law should approach this problem is a matter I will certainly come on to, because it may well be, and certainly some of the courts, one can see that in the Fairfax and Pedavali decision, one says that social and technological change should lead to a change in what the common law should be, and it should be a question of fact and circumstance in every case, what is just.
I mean, surely, the newspaper is available in the library for months afterwards. I mean, I assume that the law must have decided whether there's one publication when it's originally put out, or whether somehow it continues to be published when anyone comes into the library and looks at it.
What I propose, and I will go through, is that the cause of action, the primary cause of action, is complete as at the date of publication and as at the first date of publication.
But what do you mean by date of publication? Because my dimming recollection of a recent case upstairs was that publication occurs not when the thing is printed or distributed, but when it's read.
Well, the Le Chaux decision reiterates the common law principle that the cause of action is complete as at the date of publication.
Yes, but by publication one means reading, not...
But by one means reading by third parties, yes.
So if it's a newspaper article, is there anything in principle which prevents publication occurring whenever, effectively, however long after the thing is put into circulation, however long after somebody actually reads it?
The answer to that is it would depend upon the complaint being made. So to take the example, if the article's original date of publication is the 1st of January, that is when one assumes the bulk of the publication takes place. So the majority of people would read it on that day. If it stays online, then in principle, someone could say the first time I read it was on the 10th of January.
And if 6 months after the event, someone, and I'm not describing this case, say for the time period, the publisher says, oh, by the way, the article which we published in January was about X, Y, Z, and people then go and read it as an article about X, Y, and Z, is it not published to those readers at that later date?
The answer is it depends upon the facts in that sort of situation, because as a result of the internet, you could set up a pleaded case that you read the articles, for instance, in a different order. To take an example, you could set up a pleaded case that you are only complaining from, in this case, June or July 2009, and from that date, there is no issue about subsequent publication, because you would say that the first publication was the June or July publication, and if you read the January publications after that, you wouldn't have a problem with this issue. You would get yourself into problems, possibly, in England and Wales, certainly, with Section 1, and whether you could show that you'd been caused serious harm to your reputation.
Does time run from when anybody reads it, or does it run from when the first person reads it, or does it run from when the last person reads it, if encouraged to read it at a later date?
It runs from the date that the publication is first published.
Yes, but we all know that means read.
But ordinarily, the claimant wishes to complain about the original publication, because that's where the largest extent of publication is going to take place, and that's therefore where the damage takes place. If you set up a situation where you say you manufacture a much later publication, and that was the facts of the Duke of Brunswick case, which ultimately led to the abuse of process argument in Dow Jones, that you set up, you pass the publication to someone to read at a much later date. You may well find yourself with no publication at all, or such limited publication that the claim is almost an abuse, or doesn't, in England and Wales at least, overcome the Section 1 test.
But it might well be that a defamatory statement which doesn't identify the people being defamed is widely read but causes no damage to particular individuals, and is then followed months later by an identification of the people, and it is then much less widely reread, but in circumstances which do, in the minds of those people, lower the reader's estimation of them and cause the damage.
Well, I will come on to that, because I will take you through it, but essentially the point is, the starting point is, what is the principle, or what is the rule in respect of relying upon subsequent publications? But it may well be that you can plead and establish a case where you take the publications out of order, or they are so close in time that you are dealing with, say, one publication, or you're not dealing with the original situation you started with, which is the months in advance. And I will take your lordship to where and how the courts have grappled with that point, because some have started with the general principle, the Grappelli principle, that cause of action is complete on publication, and then you look to exceptions. And as I said, the latest down the line in the New South Wales Court of Appeal is essentially to say judicial and technological change requires simply looking at what is just and fair in the circumstances. Can I just frame this within the context of this appeal as to the two questions? And
of course you can.
If I take you to the first instance judgment, which is in the core bundle. It starts on page 007, but it's at paragraph 39 on 0021.
Yes.
His Lordship says at 38 it's undisputed that the claimants are not named in either of the two publications, and then he identifies the sub-issues. The first is whether the subsequent articles of the second defendant, which named the claimants as the officers involved in the Wallerfield shooting, and which incidents were subject to the coroner's inquest, served to identify the claimants as the persons referred to in the first article and the editorial. He makes his findings of fact from having addressed the Grappelli-Hayward tension. He makes his findings of fact at paragraph 50.
Very sorry, Mr. Speaker. Was that the electronic page number?
Yeah, 0021.
My computer's been set up with the wrong case,
Well,
I believe, or it's...
well, 21 is not produced.
There's a different electronic number, actually. I think it appears twice.
So this is internal, page 15 of 28. And certainly on hard copy, it is, as you say, 21.
Try 0369, that'll get you
Yes,
near about.
mine starts at 1683, the judgment of the judge.
Well, it's in two places, isn't it?
It is,
Least.
my lord. It's in the volume 1 at 0346. It's
But the core, I mean, the core bundle version of what is our page 21 is, I think, 1697.
would it assist you to go to volume 1, 0346?
1697.
It's in two places, and in fact, we had to look
Yes.
at the second copy because, as you probably spotted, Mr.
Last 4
Speaker,
pages are missing.
CPSAD J's judgment in the core bundle finishes on page 24 of 28. Actually, the remaining 3 pages are not relevant because they're dealing with the Reynolds defence.
I apologise for that, my lord. Would you like me to take it from the electronic bundle 0346?
Yes.
Yes. Very well. Then it's...
So where is it within...
Paragraph 39 is at
0360?
0360.
Yeah, got it.
Yes, very well.
So the first sub-issue identified by the judge is whether the subsequent articles can be relied upon. And his findings start at paragraph, having addressed the law, at 50 to 52 on 0364 to 0365. And he identifies 4 reasons. Firstly, the lapse of time, the considerable lapse of time between the articles. The fact that the subsequent articles, 3rd and 4th, are not republications of the first 2, which was the case in the Bradley decision. 3, that there's no nexus between them. Whilst they all relate to the Wallerford shooting, they don't refer back to the defamatory imputations in the earlier articles, and that no one gave evidence to connect them. And they're all findings of fact.
So I mean, we see firstly the lapse of time in paragraph 51. You break this down into 4, do you, Mr. Speaker?
My Lord, I do.
So just tell us where we put 2, 3 and 4.
So 51, the lapse of time is in line 2. 5 lines up, he identifies the Bradley decision, which was largely a repetition of the first article,
Yes,
and he says that that's not the position here.
yes, quite.
Halfway through 52 are the words, the sufficient nexus. So he is identifying, correctly I submit, that the subsequent articles don't refer back to the defamatory imputation in the first two. And then the final sentence is that there was no evidence, in fact, that anyone made a connection
Yes, I see.
between them.
Okay, thank you.
And then the Court of Appeal which is not in that bundle. The other place the Court of Appeal is in is at 0654. 0654, my lady.
Yeah.
Yes.
And the findings there are 34 to 38. And in essence, the court disagrees, accepts that the judge applied the law of Hayward, the Hayward test, as it's put correctly, but disagrees essentially that the time lapse was significant or so substantial that it's meant that the two later articles couldn't be relied upon to identify the claimants as the individuals in the first two. Mm. And in essence, at paragraph 38, I hope I'm not doing an injustice to the judge, she essentially finds, because she doesn't agree with the first instance judge's decision, it's plainly wrong.
Well, she accepts that that's a standard. She's got to show that the judge is plainly wrong. Is that common ground?
She accepts the standard is plainly wrong, but in my respectful submission, she doesn't.
Where does that leave us if we think?
Well, this is where it leaves you, my lord, and I'm going to come on to this. If I am correct on ground one, yes, that the cause of action is complete on publication, then the first instance judge shouldn't have applied the Hayward.
Oh, if you're right on that issue, then you get home.
I get home. If I'm wrong on that, and there is an exception, then the question is, what is the scope of that exception? And I say that whatever the scope of that exception is, however widely drawn, it doesn't cover articles 6 and 7 months later, where there's no sufficient nexus between them, and therefore it wasn't open to the Court of Appeal to overturn the judge for that reason. And even if there is an exception, she didn't apply proper appellate reservations that it was for the first instance judge to decide the case on the facts.
Mr. Speaker, can you just help us, if we go back to, the trial judge, paragraph 50, and I'm afraid I don't know what number that is.
364.
Thank you, 364 apparently. Final sentence, Mr. Speaker. The court, funnily enough, he refers to himself in the third person the whole time, doesn't he? The court, having considered the evidence in its entirety, found as a fact that the subsequent publications were not capable of identifying the claimants as the subject of the first article, and the editorial court's view, subsequent publications didn't serve to establish the identity of the claimants. Subsequent publications not capable of identifying the claimants. Can you just explain what the judge meant by that, Mr. Speaker? Because quite clearly, objectively, the naming in the June articles did identify the unnamed police officers in the earlier one. But so what's going on here?
What is going on here is that what he is looking at overall is whether the cause of action is completed by the naming of them in the 2 subsequent articles. And that is not simply the fact that they are named, but that the fact that they are connected or associated with the defamatory imputations that are published about the police officers in the first 2 articles. So it is more than simply saying, these are the police officers. It has to be that these are the police officers who are the subject of the defamatory imputations. And that's why he identifies that nobody in fact connected them, that there was no evidence that if one applies the test for unnamed claimants, that reasonable people, reasonably acquainted with them, would understand them to be the individuals identified.
Well, it's not quite what that sentence says, but you say it's what it means, particularly when you go on and read the later paragraphs. Is that right?
My lord, indeed, yes.
I'm sorry, isn't he just saying identifying, using that as a term of art in libel law, not capable of identifying for the purposes of the rules about identification?
In order to complete the cause of action?
Yes, as a term of art.
Because what more than simply saying that these are their names and these are the people is required on identification to complete the cause of action.
You accept that?
Can I just take you back to the idea that if you can have a cause of action arising once the names come out in the second set of articles, that's an exception to the basic principle. The basic principle that you are working on is that the cause of action is complete on publication. Is it really an exception if what is happening on the second occasion is that because of the names coming out, it refreshes the first article and somebody, let's say, make it simple, goes back to it and reads it again with the names in mind?
Well, that is the first ground, and what I say is the established common law principle, is that the cause of action is complete on publication.
Yes.
So in respect of the first article, all of the elements of the cause of action must exist and be known at the same time. So publication to a third party of defamatory material.
But what I'm proposing to you is the idea that there's another publication when the names come out, because you go back, and I'm making it simple and not dealing with the situation in which you've just remembered the article, but you go back and get it out again and you reread it.
This was proposed as a solution in the Hayward case, that you could rely upon the first article as a meaning innuendo when reading the second article. So you read the second article, and it names the individual, but it doesn't necessarily have a defamatory imputation in it about the individual. Now, in those circumstances, you may be able to rely upon facts in existence already, if you remember them, in order to complete the cause of action.
And I
And
appreciate
that doesn't offend against the general principle, because at that stage, the information is already in existence and known to the reader.
I appreciate that libel is complex and not my area, but it was a much simpler proposition I was putting, which is that there's another publication.
There is, my lady, yes.
And then the cause of action is a different one.
It is.
So there may be a pleading point, but the law underlying it is that there's a new publication with names.
My lady, exactly. And therefore, when
Of the
one
combination of the original article and the second one, which contains the names.
whether or not, possibly is the answer, depending on the facts, but yes, it would be a separate publication. And that subsequent publication might found a cause of action in itself, either because it's defamatory on the face and it names the individuals, or you can rely upon the first publication as extrinsic facts already in existence.
So would
not
that
pleaded
have been a respectable disposal of the Hayward case?
My lord, yes. Well, in relation to Hayward, and I'll come back to it, he could have sued on the second article, which was found to be an implication of conspiracy and murder. And since they weren't defending it as true, he would have got a lot of money without having to worry about the first one. But what he could have done was sued on the second article and relied upon the facts in the first one as facts which went to a meaning innuendo. And that was what was raised by counsel.
Quite. Referred to by Sir Stanley.
Indeed.
But in fact, in Hayward, they sued on the first one.
Both, my lord.
Oh, they sued on both, yeah.
But here, not pleaded the second one as a publication.
Not pleaded, neither the third and fourth articles here were complained about as defamatory publications in their own right, deserving of damages.
Sorry, they were.
They weren't.
They were.
They were not.
They weren't, no.
Not.
So, yeah.
Yes.
Quite.
So this argument's barred by the pleading point, is your response to that? Is it?
2 points I have to that. They could, they perhaps could have set up a case where they sued in respect of the third and fourth publications as libels, and they relied upon the first and second as the extrinsic facts going to meaning. Their difficulty in that regard, I submit, is that they were both privileged occasions. They were publications which were fair and accurate reports of the inquest proceedings, and therefore they would not have, that would be a defence to a libel action, that their names came out as part of the inquest proceedings.
I think was putting a slightly different point, which is that on the occasion when the second lot of material came out with the names in it, there was a republication, if you like, of the first document, and it was that first document that became libelous at that time.
Oh, no, I don't accept that, because there's nothing in the third or fourth publications that on their face of it make the imputations that were in the first and second article that they complained over.
Because it was exculpatory.
And because there were specific defamatory imputations levelled at them in the first and second articles. And
I was staying off the exculpatory point for the moment to try and find out the question of publication. But, okay, got it, I think.
There were publications in the newspaper in June and July 2009 which named the police officers, and the first question would be, do they bear a defamatory meaning about each of those officers?
You mean those two articles?
Those two articles, my lord.
On
yes.
their own?
On their own.
The answer's no, you say.
I say the answer.
Indeed, it's not pleaded that they did contain.
And if it bears any meaning, it's a different defamatory imputation to the one that they were complaining about in the first two articles. That situation is very different to Hayward, where the imputation was the same in the first and second article, and it's very different to the Irish Supreme Court case of Bradley, where the imputation was essentially the same in the first article where they're not named and the subsequent article where they are named.
But the case that's being put to you is that the defamatory content is in the first article but not aimed at anybody. But once you read the second article, you then reread the first article with an understanding of who it is that the defendant is intending to refer to by a gang of policemen with guns.
That is, that only works in principle if I'm wrong on ground one, that the cause of action in respect of the first and second publications are complete. And if I am wrong about that point, then ground two requires a more detailed consideration of how much of an exception you can have to the first ground. Because that might be a just view in respect of an article that comes out a day later or a week later, but is it really the case in respect of an article that comes out 6 or 7 months later?
You can't have a rule of law which depends on a number of days.
Well,
or a principle of law. Let's put it that way. That's what you're
that's why I say ground one is correct.
Perhaps we ought to hear ground one before we get further into this, because I have a question for you, but it comes under ground two.
Very well. I say in respect to the first ground that the established common law principle is that the cause of action is complete on publication. And what that means is that all the elements of the cause of action must exist and be known at the same time. And they are three. One is publication to a third party. The second is defamatory material. And the third is of and concerning the claimants. And in Grappelli, the general principle is articulated by Lord Denning I say correctly, and in general terms, and that is in the primary authority tab 9, which is 0160, I hope.
Well, I hope it is 01. I hope it is that number. I've got it at 976.
It's in two places as well, actually. May not be that.
What's the electronic?
Well, I've got it at electronic 976. Have you got it at 976?
No, two different
Yes.
You have?
I got it 976.
976, I think, Mr. Speaker.
Then I will take it from 976. The case was in respect of the pleading of a meaning innuendo. The original publication was that the well-known violinist was very seriously ill, and it would be surprising if he ever toured again, which is not a defamatory imputation. He then cancels concerts and is advertised to appear at other concerts, and the suggestion was he was lying about being ill, and therefore whether he could rely upon subsequent facts to convert an innocent statement of being ill to a defamatory one. And Lord Denning, what is 0980,
Yes.
sets out in what is the third paragraph there, what his lordship says: I would go by the principle which is well established that in defamation, be it libel or slander, the cause of action is the publication of the defamatory words of and concerning the plaintiff. The cause of action arises when the words are published to the person by whom they are read or heard. The cause of action arises then and not later. And then he addresses a submission and goes on: I prefer to go by the principle that in defamation a cause of action arises and a writ can be issued as soon as the words are published to a person then knowing all the material facts. If there are extrinsic facts, he must know them then, at the time of publication. That is when a cause of action arises. It cannot be made into a cause of action by reason of facts subsequently coming to the knowledge of the reader or hearer. Now, whilst I accept that it's a meaning case relating to meaning, and in this case extrinsic facts relating to meaning, the principle is put generally that it's by all material facts, reason of facts subsequently coming to the knowledge of the reader, and that is the general and established common law principle in respect of libel publications. And indeed, I'm not going to go through all of the cases that identify this, because I have done in the case, but my reading of it is that that common law rule that the cause of action accrues as at the date of publication was reiterated by the United Kingdom Supreme Court in Le Chaux.
Yes,
And I have
Lord Justice Dunn puts the principle slightly differently, doesn't he? And Lord Justice Templeman agrees with both Lord Denning and Lord Justice Dunn, so I'm not quite sure where that leaves the ratio. But if you've got the penultimate sentence of Lord Justice Dunn's judgment on 986, he says that he also would prefer to deal with this on principle. Publication is an essential part of the cause of action. Once there is publication, the cause of action is complete, and no room for the doctrine that the cause of action can, so to speak, be allowed to be inchoate or lie dormant until such time as some fact emerges which would transform an otherwise innocent statement into a defamatory one. So he does very much put his disposal of the case on the basis that the first publication was not in itself defamatory.
My lord, he does, and one can take from that, if one interprets it narrowly, that he is referring only to meaning. But I submit that this is correct, this, for two reasons. One is it's the crux of a libel is the publication to third parties. And it's the third party who needs to have the knowledge for damage to reputation to be presumed from the publication. And the third party doesn't have the knowledge if they're not in the possession of the extrinsic facts. I say whether that is an extrinsic fact going to reference or an extrinsic fact going to meaning. And I also submit that there's policy reason for this, which is it's a good one, that it keeps libel within acceptable grounds. And that comes also from Lord Denning, because he cites the Canadian Court of Appeal case, the New Zealand Court of Appeal case of Simon's Proprietary, and the concern over the great extension of the law of libel if one doesn't keep it in acceptable bounds.
So that's your first case on your absolute ground one. Where do we go next?
Well, let me, if I may just set out what I say of the 5 or 6 justifications for that.
Do.
Firstly, it's a long-standing and established common law principle, and it's been very recently reiterated in Le Chaux.
Where do we haven't got La Chaux here, have we?
My Lord, we do have it, I
It's in
produced.
the supplementary bundle, which
Could you
we've
just
got on.
show those of us who weren't in La Chaux where it
Tab 2,
is?
and I say it comes from paragraph 18.
Yes.
In addressing the arguments on limitation and whether the cause of action accrues as at the date of publication for the purposes of limitation, Lord Sumption, halfway through 18 on page 9, cites the argument is that Section 8 assumes that the common law rule that the cause of action accrues on publication subsists, subject only to the modification of the accrual of the cause of action for a qualifying second publication is backdated. So that's a suggestion of the common law position. And then as I read it at the top of 10, as an element in the cause of action for defamation, publication does not mean commercial publication, but communication to a reader or hearer other than the claimant. The impact of the publication on the claimant's reputation will in practice occur at that moment in almost all cases, and the cause of action is then complete. So I take the Supreme Court not to have changed the date of publication. The cause of action accrues as at the date of publication.
And indeed, it's even clearer if one reads on.
Indeed, in dealing with subsequent facts and evidence.
Yes.
Though, of course, Le Chaux wasn't in any sense about this sort of question. It's all about a question of when the damage occurs.
It was, but it had to establish what change Parliament had made to the common law.
Yeah.
And it identified the common law position, and then, although this moved in first instance and in the Court of Appeal, held that the cause of action completion date is not at the date of the public claim, form or damage, it's at the date of publication. Mm. I also submit that it's not an unjust rule in that in the vast majority of cases the claimants are either named or they are identifiable by means of extrinsic facts available as at the date of publication. It supports legal certainty in that it's helpful for publishers, insurers, pre-publication lawyers to know what the law is as at the date of publication. It's very difficult if you have to try to foresee what events, for instance, are coming about afterwards. And as I said, it keeps the tort in proper bounds, or in human rights parlance, it's a proportionate restriction upon freedom of expression to meet a legitimate claim. The downside, or the point that is made against it, which I'll come on to, is that it is an artificial barrier, since people are often interested in the identity of an individual in a newspaper or a police report, and may go looking for it afterwards. But defamation is full of what could be described pejoratively as artificial barriers, but may also be described as protections or control mechanisms. So the single meaning rule, highly artificial to some, but practicable and workable solution, as described in the Stocker case in the Supreme Court. Dingle, described as pragmatic in Le Chaux. One could have the repetition rule, the conduct rule. These are not, they can be pejoratively, as I say, described as barriers, but they can be better described as the control mechanisms to ensure that there is a proper balance between protection of reputation and freedom of expression.
Mr. Speaker, can you help me on one point? forget later naming. Just focus on here, the December article and the December editorial, not named. And there'll always be somebody out there who knows who the people are being referred to. The wife of one of the police officers, who knows perfectly well that he was part of that job at Wallerfield. Is that good enough under the law of libel?
You can call witnesses to say that you identify someone, but the test is objective. So the test is whether reasonable people could understand, people who are acquainted with the individual could reasonably understand them to be referred to. And that was the question that if it was capable, that would be the question that was left to the jury. So what one had a lot of in the 1980s in libel police actions were police officers saying, I was sitting in the canteen reading a copy of The Guardian and I immediately recognised these people to be officers in my my service and whatnot, and they would give evidence and sometimes...
Is that good enough?
Well, no, because it's an objective test. So the objective...
Well, what does that mean in this context?
The objective test, the test that applies where an individual is unnamed is one of reasonableness.
So a reasonable person who doesn't know them.
No, it may not be reasonable to identify them from the particular facts of the newspaper simply because you know them.
But that isn't going to help you when the issue is subsequent information. The reasonable test of itself, on its own, doesn't actually answer the problem we've got.
No, but it was, I think, a slightly different problem.
It's my fault. Well, I think it's my fault that I was actually excluding the later situation and simply focusing upon the fact that somebody will always know who it is.
My Lord...
And, I mean, if I want to go away and understand a bit more about that, what's the case that I should read, Mr. Speaker?
Two points on that. This is addressed in the House of Lords in the case of Morgan, and I'll show you. But it's also helpfully set out in the first instance decision, which is in the bundle of Monier and Wood. Monier and Wood, which is at...
Well, as Lady Arden says, it doesn't actually... I don't think it actually arises in this case, because that's not the way it's put by the claimants.
No, but it's...
So I don't think at the moment it arises. And so Lady Arden, I think, is right to ask me and you to focus upon the way it is put, which is to add the later to the former and make a claim.
I do...
Because the reference from Monier and Wood is what?
Yes, my Lord. It's in volume 5.
We'll come back later.
It's volume 5, and it's starts at 1439, and it sets out, Mr. Justice Nicklin sets out the law on reference at paragraph 95.
Thank you.
And
Thank you.
Cited some of it from the case.
Thank you very much, Mr. Speaker. Yes?
So those are the principles. That is ground one. That is the cause of action complete on publication, and those are the reasons or justifications for why I say that the rule is long-standing, sound, and correct. What occurs in Hayward, and it's the modern, the most modern decision, is an exception that they held that where a publication is defamatory on its face, but does not identify a claimant by name, it may be justifiable to hold the defendant liable for the words complained of where they subsequently name the claimant.
Yes.
The key justification for this appears to be, firstly, that it's just to hold a defendant liable in such circumstances. But I say that cuts across the Grappelli principle because the cause of action is not complete until the individual is identified. And from the authorities, the further justification appears to be, that it's said to show either the subjective intention or the apparent or perceived intention of the defendant to refer to the claimant in the first article. And I will go through why subjective intention is wrong. and indeed perceived intention. The other justification for it is, as identified earlier, it's an artificial and unrealistic barrier to put in place when people are going to go looking for who the individual is. But if it is an exception where the same publisher publishes a subsequent article, the next question is, how does one define the scope? And this is where the courts have disagreed and where there are difficulties. Is it where there is publication to a limited class of people already? So in Hayward, the first Mr. Hayward was identified by some people from the first article simply from the words wealthy benefactor of the Liberal Party.
Yes.
Does the period of time matter? Hours, days, weeks, or months? Should the later article expressly refer back to the earlier article? Should it be part of a saga or a series? Those are the points that Mr. Justice Eadie was saying in Chase in looking at Hayward that are unclear. But one has to grapple with them once one identifies what the principal justification for an exception is. What is its width? What is its scope?
Yes.
And ground two, part two, so to speak, is what has been established as an extension from Hayward, which is where a publication is defamatory on its face but does not identify a claimant, is it justifiable to hold the defendant liable for words complained of which where the claimant is subsequently named, but not by the defendant, but by a third party?
Which doesn't crop up here.
It doesn't crop up here, but it crops up in a number of the authorities. Was Hayward extended in the case of Baltinos and others? And the argument from that is, whilst that again that cuts across Grappelli and cuts across the general principle, the justification or potential justification is, if you say, as it happened in PJS and others, his name's on the internet, or you say go watch that program. Have you lit the fuse which objectively judged is going to lead to identification, as Mr. Justice Eadie put it in Chase? Are you pointing the finger, as Mr. Justice Hunt put it in Baltinos? So Hayward has been extended to liable for the actions of a third party. You say not the situation we're dealing with here.
What's the case on third party issuing the second publication?
The first extension from Hayward was a case called Baltinos, Baltinos.
In New South Wales?
That's New South Wales, yes, my lady.
Yeah, very well.
The last point is, should there be no principle at all? As the New South Wales Court of Appeal essentially appears to be saying, that, and again, the justification that the correct judicial response to social and technological change is to ask what is just in the circumstances.
Well, we'll try and do better than that, Mr. Speaker.
I'm grateful. And then my last point on is policy exceptions. As I identify in the case, if there is an exception to Grappelli, are there situations where subsequent articles, perhaps for policy reasons, should be inadmissible? And I identified two in this regard. One, where the extrinsic facts are taken from privileged publications, reports of an inquest. Second, perhaps where they're exculpatory.
Yeah.
Inadmissible, I mean, that's quite a strong submission.
Well,
You might say that where it's exculpatory, it doesn't cut the mustard. You can't add the naming to the first publication without also looking at the wider nature of the second publication, which is exonerating or exculpatory. But you go further and say it's actually inadmissible.
Well, I'm happy to have it. I'm happy for it to be put that way. My submission in the case is that to complete the cause of action, that it means about these claimants that they were party to a murder by reference to publications that say they've been vindicated of
Well,
that.
quite.
That shouldn't be allowed to. You shouldn't be allowed to rely upon those.
Well, that's an interesting line.
I mean, it may be a policy ground, or it just may be an analytical ground, that 2 added to -2 doesn't make 4.
Perhaps they're different. Perhaps privilege may be, yes, it may be that. It may be analytical rather than policy. And privilege may be a separate point to taking the bait.
I can see why there may be a policy behind it, which is if the original publisher wants actually to make clear that he doesn't think what he previously said was right or not, and if it's only there that you get the link, it seems quite tough then imposing on him the liability.
My lord, indeed, that's the point I raise.
But to have either of these exceptions would in fact give an incentive to publishers who did not fulfil the requirements of Reynolds at stage 1.
That, I accept that is a consideration because, as I'll come to show, there's a New Zealand case where they do look at the question of whether you can rely upon extrinsic facts from words coming out of Parliament but are not subsequent, they're already in existence. And that is a point that is raised there, and I will, if I may, address that.
Mr. Speaker, I think we should speak up more, and I think you should speak up more, because there are people who've been interested enough to come in and sit at the back of the court and may not be hearing everything that we say.
I apologise if I'm too quiet. I'll speak up. Can I now take you to Hayward and Thompson and deal with...
Certainly.
Now, I have to try and find the alternative. 987. As explained, this involves the Jeremy Thorpe-Norman Scott affair. The first article referring to 2 more individuals involved in the Scott affair, one described as a wealthy benefactor of the Liberal Party. Second article, a week later, identifies the wealthy benefactor as Jack Hayward. Now, the articles are published in 1978. There is a big gap before the trial because in that period, Thorpe and his 3 individuals are prosecuted and acquitted in the criminal trial. So there's quite a lot goes on outside of facts of the case, but in essence, there's a long gap, and then by the time one gets to the trial, the only defence that is being run by the newspaper is not defamatory, or it doesn't bear the meaning, which is not a great defence here.
So the acquittal of Jeremy Thorpe and the others was prior to 1981. Is that what you're saying?
My lord, yes, it was.
Very well.
But I'm saying something else. It was prior to the first instance.
You are saying that. Thank you very much.
And the other thing that happens is that the Sunday Telegraph is heavily censured by the Press Council for paying Peter Bessel, the MP, offering him £50,000
yes.
if Thorpe is acquitted and £50,000 if he's guilty. So that's the background to going into this libel action. The judge, Mr. Justice O'Connor, does 2 things. He allows the jury to look at the second article to identify Mr. Hayward as the subject of the first article, and, as is in his discretion, he allows the jury to come back with 1 verdict on damages, so 1 award of damages for both articles. So when the defendants appeal, one of the grounds is that that was a misdirection, and because the Court of Appeal had no power in 1981 to substitute their own award of damages, to substitute the jury's award of damages for their own award of damages, if there was a misdirection on allowing the jury to use the second article to identify Mr. Hayward in the first article, there would have had to have been a retrial. 3 judges give different reasons for finding that the judge was right to have allowed the jury to consider the second article. And Lord Denning starts on page 20 of the internal, which I'll just find, 1006.
One 006. I thought it was 0993.
Sorry, I'm swapping now between the two. 17, paragraph, page 13 internally is
Oh, I see.
0999.
Yes, okay.
The consideration of identity starts on the page before at 0998, where the submission is put by the appellant defendants that the Grappelli and Derrick Block principle is correct. And his lordship at the top of 099 distinguishes it on the basis, A, that the words are defamatory on their face, and then goes on to say, if the word should be defamatory and untrue and should be published often concerning the plaintiff, that is, the plaintiff should be aimed at or attended by the defendant. If the defendant intended to refer to the plaintiff, he cannot escape liability simply by giving his name. He may use asterisks or blanks. He may use initials or words with a hidden meaning. He may use any other device, but still, if he intended to refer to the plaintiff, he is liable. He is to be given credit for hitting the person whom he intended to hit. The law goes further. Even if he did not aim at the plaintiff or intend to refer to him, nevertheless, if he names the plaintiff in such a way that other persons will read it as intending to refer to the plaintiff, then a defendant is liable. This is settled by Holton and Jones, in which the House of Lords expressly approved the judgment of Farwell LJ in the Court of Appeal when he said, if a man chooses to make statements of fact about a person whom he names, as in this case, I see no reason why he should not be liable to everyone whom he injures, who can convince a jury that he's reasonably intended by the words used. I say there are 3 reasons given for why Grappelli is distinguished. The first is that it is defamatory on its face, and I say that that's not a proper or logical reason to draw the distinction where one is looking at the cause of action being complete as at the date of publication.
Mm-hmm.
Say that subjective intention is no part of English law, and Lord Justice Farwell's judgment was said not to be followed since 1941. And I'll take you to where I find that. First, Holton and
What did Lord Justice Farwell mean when he talks about a claimant convincing a jury that he is reasonably intended by the words used? Does that mean it was intended that he be identified, or is he actually saying, in language rather alien to ours now, that he is reasonably identified by the words used?
My Lord, may I take this in order, because no one quite understands what Lord Justice Farwell said.
Very well.
Well, one presumably needs to read it in the context of the case, rather than just a little snippet that's been extracted and cut and pasted into this one.
Can I take you through this, my Lord?
Yes, do.
Volume 5, page 1274 is Holton and Jones. This is the decision of the House of Lords, which moves or establishes the march from fault-based liability in libel to strict liability. And it's about the case of the barrister called out Artemis Jones.
What page is this?
I have it at 1274.
1274. Yes, thank you.
Yes. So, tell us about this case, Mr. Speaker.
This is a case in which the newspaper published a fictional account about a fictional person called Artemis Jones, without realizing that there was a barrister called Artemis Jones. And the question was, does that matter? And the answer or the finding was that in an action for libel, it's no defence to show that a defendant did not intend to defame the plaintiff if reasonable people would think the language to be defamatory of the plaintiff. Now, Lord Lawburn, Lord Chancellor, gives the lead speech, and it's at page 1277. He says, after the first sentence, libel is a tortious act. What does the tort consist in? It consists in using language which others, knowing the circumstances, would reasonably think to be defamatory of the person complained of and injured by it. A person charged with libel cannot defend himself by showing that he intended in his breast not to defame, or that he intended not to defame, if in fact he did both. And therefore this is, libel is strict liability, objective tests. You cannot get away with saying you didn't intend to libel someone if they're reasonably referred to. Now, over the page, what happens is that Lord Atkinson concurs with the judgment of the Lord Chancellor, but also says he concurs substantially with the judgment delivered by Farwell LJ. Lord Gorrell says he concurs with the judgment of Lord the Chancellor and concurs with the observations of Lord Atkinson upon the judgment of Lord Justice Farrell. Lord Shaw says he concurs with the findings of the Lord Chancellor.
Are we really concerned with digging around in a case decided 100 years ago to see whether or not someone agreed with something said by the Court of Appeal?
I was just going to make the point that because of the confusion here, the Court of Appeal in 1941 said what one needed to do was follow Lord Lawburn and Lord Justice Farrell, and that's what the Master of the Roll said in Newstead, which is in the supplemental bundle.
So you think Denning got it wrong? It seems to be a consensus that Lord Denning went too far.
My Lord, yes. I'll just give you the citations if you don't wish me to go there, but Newstead, that's what is said in Newstead is one needs to follow the strict liability, that intention is not the law.
Yes.
And
Thank you.
that is accepted in the subsequent cases on this question in Bradley in the Irish Supreme Court at 0075, paragraph 44, and in Chase at 0087, and indeed, importantly, it's accepted in the Court of Appeal in this case.
Sorry, the it in that sentence was?
Intention is irrelevant.
Yes.
So the other two judges, Court of Appeal judges in Hayward, give different reasons for reaching the same conclusion. Sir George Baker.
Yes, rather irritatingly, on 1002, I don't know how the electronic thing works out,
His name's
but on
missing.
paper, it wasn't obvious that Sir George's judgment starts halfway down.
My Lord,
But it does, doesn't it?
My Lord, it does. I apologise for that. His name is missing for reasons that I simply cannot explain.
No, fair enough, fair enough.
So whereabouts on the electronic version does Sir George Baker's judgment start?
1002.
Thank you.
Yes.
And 4 pages on from that, page 20, which is 1006, the reasons given are in the second main paragraph, but a statement that 2 or more persons are connected with the Scott affair has been given to the police would have been dull stuff. Interest has been titillated by introducing a wealthy benefactor and a businessman. It seems to me to have been a kind of crossword puzzle, or colloquially a whodunit, with an invitation to solve the identity from a clue, a wealthy benefactor of the Liberal Party. Why else was it written? So I take from Sir George Baker's judgment that he his three reasons are: one, the original article is not defamatory or is not innocent; two, that it's a crossword puzzle, or colloquially a whodunit; and later on, his lordship refers to the second article being part of a saga or a series. That's on page. That's still on page 1006. Lord Rawlinson says it was a saga or series. And the third judge, Sir Stanley Rees, his judgment starts on 1009. And the reasons, he raises the question halfway through the main first paragraph, essentially that the original article in Hayward was defamatory on its face. The second article explicitly identified the plaintiff, and that the second article was published by the same party who published the original article.
Yes.
So neither of those two judges focus on intention, or all three say that it's the same defendant and it's defamatory on its face.
But it turns on the very special facts of our somewhat special case.
My lord, they are very special facts. It's a very special case. There was a real desire not for the Scott affair by this stage for a line to be drawn under, and the idea of a retrial of the libel action wasn't desired by anyone. And that would have been the effect of deciding that the first instance judge had misdirected the jury to take into account the second article to identify Mr. Hayward in the first.
Mm-hmm.
I submit that as it happens, Grappelli remains the general principle correct and shouldn't have been distinguished upon these grounds. But once you do make an exception, it tends to grow. And in fact, it's what happened in Baltinos only 5 years later, where Mr. Justice Hunt extends it to the question of where a defendant extends it beyond a publication by the defendant to a publication by a third party, if the defendant had encouraged or pointed the finger to where you would find the identification. The courts don't find it easy to identify what was the ratio of Hayward, and it is articulated in various different forms in the different subsequent cases. In Baltinos, which is at 0845.
Yes.
It is defined at the top of 0849, having set out Grappelli to be the basic principle of defamation law at the bottom of 0848. Hayward is described as, in the first paragraph, qualification in respect of subsequent publications by the defendant justified on two bases. The qualification at the top, a qualification is in that the plaintiff may rely upon the subsequent publication by the defendant where the matter complained of is defamatory on its face and where the subsequent publication by the defendant is used only to identify the plaintiff as the person referred to. So that's quite a wide, I submit, interpretation of the ratio of Hayward, but that's what the judge finds there.
So what limit on the exception does Hunt J put?
Well, he doesn't. He extends the principle to allow, in this case, this is a case in which there is a newspaper article in the morning that describes a television program later on that day involving individuals who are described as rapacious con men but not named. And it says, watch the program. And they are named in the program. And he allows the question to go before the jury that in order to identify the defendants in the article, you can look to the subsequent publication in the television.
And it's all on the same day?
Yes, my lord, yes. And he
Well,
found that...
The article is directly related to the programme. It says,
Yeah.
it's going to be shown this evening, we recommend you watch it.
Yeah.
Indeed, but it is still a subsequent publication to identify
Yeah.
the individuals named. But as my Lord Carnwath says, it's a very short period of time.
Yeah.
And that is one consideration that might be relevant to whether subsequent publications can be admissible contrary to the general principle that the facts must exist at the time.
Of course, Mr. Skerritt is going to say, look at the editorial in the December publication, which said, watch this inquest.
My lord, he is. But that doesn't relate to the imputations. It doesn't relate to the defamatory articles, the inquest. It's quite different. Boltinos is different because it was the same subject matter. It was, in essence, a review or a preview of what was coming up on the same day. And all that was being done, at least as the judge considered, was leaving to the jury whether they could rely upon the later article that day to identify the individuals from the earlier publication.
Yes. Would you say it was implicit in the second justification identified by Mr. Justice Hunt that the first article is still fresh in the mind of the reader when he reads the second one?
Well, that's certainly a strong consideration, yes. And that would be the same, that might well be the same as Hayward, that it's only a week.
Well, I wasn't, yes, I mean, it may be just a simple question of time. It may be a question of notoriety, and there may be all sorts of factors that feed into the fresh in the mind concept. I'm really asking whether that's inherent in the justification, in the way it's described, because it would lead the reader to infer from what was published that the defendant had intended to refer to the plaintiff. Well, you can only make that inference if the earlier article is still in your mind, isn't it?
Yes, my lord. He cites this on two intent. He looks at intention on two bases, and it's a pretty difficult judgment. At least I found it so, because he looks at both subjective intention and leads himself to a conclusion where, because of a Privy Council decision that at that time took precedent over a Federal High Court of Australia decision, he could look at the subjective intention. But he says that's wrong in law post Holton and Jones. So then he goes back to what was the perceived or imputed intention. What is it that the reader would understand the position to be when they read it? They would understand it to be you're referring to the person on the programme.
Yeah.
Yes, so, I mean, that's the head note, and it properly reflects the penultimate paragraph of the judge's judgment.
Yes.
And so you're able to say that that was a case where the defamatory publication said, you'll find out who they are if you watch the programme. And you say that nothing analogous can be read into the December publications here.
I do certainly do say that in respect of this case. But I mean, it didn't have to be done here because Boltinos was suing the programme as well as the newspaper, and therefore he had a libel action. He had a claim against the programme as well as the newspaper. But that is in the authorities, and a potential exception is where you point the finger or where you where you identify. But but what one has to understand in that regard is you have to be very careful with that as a submission, as a foundation for an exception to the law, because it's just too easy to satisfy. And to give you an example outside of the tabloid journalism, if one takes the police are encouraged these days to issue press releases and, for instance, to state that an unnamed man, aged 31, is arrested on suspicion of murder, for instance. And policy dictates, do not name people for privacy reasons. If you take the view that you're pointing the finger, or it's reasonably foreseeable that people are going to be interested in who that is, it's very easy to found liability in that regard. Because almost everyone out there will say, in respect of the police notice, I wonder who that is, that must be X, that must be Y, I'll put on Twitter or social media that it's someone. So it might be desirable, that might be fair when one looks at the tabloid journalist, the tabloid newspaper publishing the silhouette of an individual on the front page saying Premiership star in rape scandal, and people thinking, oh, they're nudging and winking, who is that? It's only fair to hold them liable if someone finds it. But the same thing can happen in far more serious situations, which is, for instance, the police releasing information about an unnamed person being arrested. And it's not necessarily the answer to that there's a defence, because one doesn't want to get into the position that one has to deal with an action.
Yes?
Just following some of the court cases through on this, the Supreme Court decision in Bradley in the Independent State Star newspaper is considered in the Court of Appeal judgments and the first instance judgment here, and that is 869.
Yes.
This is a decision that relates to two articles about alleged bank robbers, in which they were not named in the first, but they are named, and they were not named in the first and they lost the action, and they were named in a second and brought a second action. The question at trial was whether there was a misdirection about whether they could look to the second article to identify them as the individuals in the first article. Did that make sense? Because it was already before the jury, that material, on the issue of general bad reputation. And two of their lordships give judgments. The first is of Miss Justice Hardiman and starts on 0880. Poses the question at the top that where a defendant publishes one article which did not name a plaintiff or otherwise clearly identify him, and subsequently, as in this case, publishes another article with both names and identifies him, and which refers to the first article and actually includes a photographic representation of it, is the second article admissible in evidence for the proposition that the first article was published of and concerning the plaintiff? As we're about to see, the simple question has led to conflicting judicial decisions which are difficult to reconcile and to much confusion in a number of common law countries. Most relevant is the conflicting English authority cited both at the trial and on the hearing of this appeal, and then they go on to address the Grappelli and Hayward tension.
Yes.
Before concluding at 0884. It departs from Lord Denning on intention at the bottom of 0884, cannot agree with the last quoted statements of Lord Denning in as much as...
You've got that point, Mr. Speaker.
I'm grateful. but does say at the top of the next page, does not mean, however, that the evidence of the same author and publisher published a subsequent article is inadmissible and must be excluded from consideration. To do so would be highly unrealistic in the sense that it would exclude from the jury consideration of material which every person of normal intelligence would consider relevant to the question, who was the first article published about? It's one thing to say intention is neither necessary nor sufficient to constitute a libel. It's quite another to say that a specific article, undoubtedly published in the same newspaper and by the same journalist, was an employee of the same defendant, must be excluded from consideration on the question of identification. Again, what they find is that the important criteria is A, that it's not innocent, B, that it's published by a defendant, but the distinguishing feature from the case at hand is that the second publication is a republication of the first one.
Well, it was the two claimants saying, it's not us, but that was not in the context of the newspaper accepting that it wasn't them. And as you say, the first article was actually republished alongside the denials of the claimants. Is that right?
My lord, that's correct, yes. And that's a distinguishing feature from the present one.
Yes, I'd noticed on 80890, paragraph 11 of Fennelly J's judgment, where she, I'm sorry, I don't know which, says that the second article repeats the general gist of the article of 13 June.
My lord, it did both that and there was a picture of the first article in the second article.
Yes.
So,
or at least the first 2 pages of it. It's paragraph 52, isn't it?
But the proceedings were only brought on the first article.
that's correct.
So there was no pleaded claim based on its republication in the second article.
No, but it was before the court on the question of general bad reputation.
But although it was a case of republication in fact, it wasn't the republication that was sued on. Yeah.
At the outset of your explanation of the Bradley case, you referred to two actions, and indeed there were two, and one of them you say failed, as if I didn't quite follow what the constitution of these proceedings was, Mr. Speaker. Can you clarify that, please?
As far as I understand it, as the background is explained by Mr. Justice Hardiman, that there were appeals in two libel actions. I believe the first libel action failed on the basis that they couldn't establish identification, and that was in respect of the first article. And then the second action, well, my Lord, it may be that I may have a look at that over lunchtime as to the precise nature of it.
Yes, thank you.
Back to you. But what I say are the important points in Bradley are that the admissibility of the second article is on the basis that it constitutes, as Fennelly J says at 52, a more or less explicit republication and reference back to the first article. And that is a very different situation to the current one. Moreover, they didn't really need to rely upon the first article because they had a complete cause of action in respect of the second one. So it may be somewhat academic as to whether it mattered. But there is also no appreciation in the judgments I submit of the importance of freedom of expression here or the control mechanisms in place to safeguard against allowing the torts to be extended too widely. Next is Mr. Justice Edian Chase. Which is at 905.
What he does is it's all very difficult.
What he does is, he declines to strike out on an interlocutory application. But the facts of this is that the Sun published on its front pages the story that an unnamed nurse was being probed over 18 child deaths. She was not named, but one of the particulars of reference that she relied upon was that a High Court injunction in place preventing her identification was lifted the day after the article, and that led to widespread publication of her name. And therefore the issue in the case was whether or not that subsequent publication could be relied upon to identify her as the individual at the centre of the articles on the 22nd and 23rd of June. And there is a discussion in this judgment about how one approaches the various aspects of Hayward, which leave scope for uncertainty. That's on 0907 in the 4th paragraph.
Yes.
And with reference to two of the New Zealand cases, what I submit is maybe of assistance are the points that are identified as the reasons for why one would overcome the Crapelli test at the bottom of 0908. The first of which is the reasonably understood to be deliberately targeting a specific individual. Second of which of littering identifying clues, which again I say we didn't have identifying clues such as to invite or encourage readers here. Again, timing and content, in reality the cause not only of an immediate media frenzy. So again, one is we're not in the same situation, and the reference to the submissions in Hayward of a saga or a series. What we're again dealing with here, where in a situation where it might be just to have an exception, is one which comes very close in time, the day after the articles are published, where there are hints and nudges and such like that lead individuals to identify the person. And I submit that we're way outside that in terms of timing, and outside of that in terms of the type of information that was published in the two initial articles. The last authority in this line is the New Zealand Court of Appeal case of Fairfax and Pedivoli, which is at 916.
So, what was this case about, Mr. Speaker?
In this case, a female teacher resigned from a boys' high school in December 2013 following allegations of sexual misconduct with Year 12 boys at the school. The Sydney Morning Herald published an article in January 2014 stating that the teacher concerned was in her late 20s and taught English and drama. The plaintiff was not the teacher, but she was in her late 20s and the only teacher who taught English and drama. The Court of Appeal holds here that where a publication is defamatory on its face, it's not necessary for the plaintiff to show the identifying facts were known to readers at the time they read the material. The question is whether the readers identified the plaintiff as one of fact and degree, and that they held that it was open to the primary judge to find that readers who went to the school's website had identified the respondent as the teacher concerned. Importantly, I submit, and it's similar to Hayward, and Justice Simpson's judgment starts at 39 on 0929, she holds at 42, or identifies at 42, that there was no issue that the respondent was identifiable from the information contained in the article, nor was there any issue that she was in fact identified by some readers. So a distinction with the present case is that it was not in dispute in Fairfax and Pedavali that irrespective of whether or not you could rely upon subsequent identification by heading to the website, it didn't matter to complete a cause of action here, because from the facts in the newspaper article itself, she was identified.
Sorry, where is that?
42, my lord, on 0930.
Oh, I misheard your page number. Thank you.
Therefore, the judge asks herself the question in that paragraph. The question that gives rise to these grounds concerns the number of readers who were shown to have done so, and therefore the extent of publication of the defamatory imputations, and specifically whether it's legitimate in determining the extent of publication to take into account readers who identified the plaintiff as a result of information obtained subsequent to the publication. So what one's looking at here is not, I submit, whether the test for identification to complete a cause of action. One is looking here in reality at the extent of publication on the question of damages.
Mm. Then how helpful is it?
Well, because they go through and consider that Grappelli is too widely drawn, that isn't a general principle, that one should rely upon fact and degree. I cite it so that your lordships have it, because it contains the most recent discussion on the tension between Grappelli and Hayward. And the judge leads herself to a conclusion, having gone through this at 81 on 0944. It's not, in my opinion, that the law that a publication which does not name a plaintiff conveys defamatory imputations only to those respondents who, at the moment of first receipt of the publication, know the identity of the person referred to. Whether or not the plaintiff has been identified as a matter of fact and will depend upon the circumstances of each case. It was to deal with particular circumstances of their own cases that the judgments in Hayward, Baltinos and Strasbourg developed, rather than provide exceptions to the principle as stated. It may well be that questions of remoteness arise, but that's not the case. Her ladyship recognises by raising the question of remoteness that what one is really dealing with here is damage than liability. And I don't dispute that what is admissible on the question of damage once the libel is established is wider and should be wider than the test for identification at the cause of action stage. And the law, as outlined in the case, from cases such as Slipper and the BBC, is one can look for the natural and probable consequence arising out of a defamatory publication. And that may well be that people run off and talk to other people about it. And therefore you have to compensate a claimant who has established her case sufficiently to allow her to point to an award of damages appropriate to be able to nail the lie, to be able to say this is false. But that doesn't mean one throws out the general principle on how to establish liability and what the cause of action should entail by simply saying it comes down to a question of fact and degree. And therefore, properly understood, this is a case that would have been better considered on the basis that some people identified the claimant from the article. They would inevitably or naturally talk about that at the school. Since it's false, she's entitled to an award she can point to sufficient to demonstrate that it is false. But it doesn't support, although the argument is all here, it doesn't support a move away from the principle in Grappelli that in order to found a cause of action, the facts must be in existence as at the date of publication.
But the principle must be consonant with common sense, must it not? So if you have a situation where, as a result of a subsequent piece of information, the person reading it would say, wow, that was them in the first article, why shouldn't that be a sufficient identification?
If the information that they learnt was subsequent, yes, because there has to be control mechanisms of some kind in order to keep a proper balance between reputation and freedom of expression, and that is what the Grappelli general principle does. Second, the wow or the subsequent publication could be sued upon as a publication itself, referring back to the first publication and relying upon the first publication as the extrinsic facts to explain why the second publication is...
That may not give a proper remedy if the first article is the really damaging one.
That would depend upon the facts. That is one of the reasons why one can see the courts have decided...
Right, and the policy might then be that one ought to remedy a situation given that it's a person's reputation, which obviously is very fragile.
Indeed, but then one comes back to the question raised in Ground 2 and Hayward as to what is the scope of that, because it can easily be expanded from a publication the same day to a publication a week, month, year.
It cannot depend on the number of days. You can't have an artificial rule saying, well, that's identification, but that's not, because that was 3 weeks rather than the same day. But if you can say, wow, when you've read the second article, that was them in the first article, isn't that good enough? It's a different situation from where you read the second article and you say, really? Was it those people in the first article? Because you're using the second article to address a different problem, to reach your conclusion. But if it's really just clarifying what your understanding of the first article.
Well, I do come back first off to the fact that three elements are required to have found the cause of action, and they should exist at the same. They should be in existence at the same time in order for the cause of action to be complete, and that is reference, meaning, and publication to a third party. If the second publication is defamatory of itself or may found a cause of action, then one can sue upon that. If that is a lesser publication or it is more difficult to sue upon, then that may be that one can't establish that all subsequent publications you can't establish that the defendant may be as able to pay the damages as the primary one. It will just depend upon the circumstances. But the common law principle is a sound one because it is clear and it keeps the tort in proper bounds.
So what is the test? I mean, you've told us that the court's been struggling with this for the last 40 years without getting very far. What do you say is the test?
Well,
We've got the basic, you say the basic principles of Grappelli is straightforward, but you have to acknowledge that there are exceptions to it. What do you say is the test for the exceptions?
Can I just deal with the two exceptions of privilege and exculpatory facts, and then I'll show you where I am on the wash-up of that.
Okay, as long as at the end of it we get your submissions, principle is.
Okay. Oh, you will, my lord. The final 2 points on exception are the ones raised earlier of whether it matters that the extrinsic facts take place on a privileged occasion and whether they are exculpatory.
And as I understand it, the principle you put in relation to privilege is that if A2, the second article, is privileged, then it can't supply what's missing from just looking at A1.
My lord, yes. And
Is that what you're saying?
what I come to this from the decision of the Court of Appeal in Curraston, where it held that it's a statutory rule that a fair and accurate report of parliamentary proceedings was privileged, and that any common law rule should give way to that. And therefore, if the articles 3 and 4 here are privileged, and they are a fair and accurate report of the inquest proceedings, and no one suggests otherwise, that should give way to any allowance to rely upon a subsequent fact that is taken from that privileged occasion. So to make that clearer, because that wasn't very clear.
What's the case on that?
Curraston, which is at 1140.
Where is this in your case?
0797.
Thank you.
Paragraph 98. I deal with 2 points. What I say is that the 2 later articles
Yeah.
are exculpatory court reports. The first, reporting on the evidence of the pathologist, and the second on the outcome, identifying that the actions of the officers were not negligent. I then identify at paragraph 98 that there's a very strong interest in the public learning what takes place at an inquest into a shooting, with reference to the House of Lords decision in McCartan. And then go on to the Curraston decision, because what I say is, in order to protect the high public interest in reporting upon court proceedings, including inquest proceedings, one shouldn't allow a claimant to extract facts from such reports and sue in respect of an article published 6 or 7 months earlier.
Was this a point taken in the court below?
No, my lord, but it's a point of...
And there's an equivalent of the Defamation Act, is there?
There is an equivalent to the Defamation Act, my lord, yes. It's set out in the footnote on page 0798, section 13 of the Libel and Defamation Act provides a reporting privilege. It's not a point taken, I accept, below, but I believe it was taken that the articles are exculpatory, but not.
Yes, that does appear to some extent. Well, we've got a judgment of my lady here, Lady Arden.
Yes.
Whereabouts in her judgment should we go, or are you simply making the general point about privilege of these reports? Do we need to look at the judgments, important no doubt though they are for some purposes?
I was, paragraph 25 on page 1156.
Yes.
Which was a discussion of whether the repetition rule survives the law of statutory privilege, presupposes the existence of the repetition rule. Section 15 of the 1996 Act, which is that there is a privileged offence for a fair and accurate report of court proceedings. Provided those conditions are met, the report is privileged, and therefore any common law rule, in this case the repetition rule, that would diminish or destroy this privilege would have to give way to the statutory rule. And by analogy, I submit that any exception to the Grappelli principle that would allow extrinsic facts, subsequent extrinsic facts that arise from a court proceeding or a court report should give way to the statutory rule that such occasions are privileged.
Privileged at common law? Or,
Under the Trinidad and Tobago equivalent of the Defamation Act.
do we have that particular statutory remedy?
We have a reference to it in the case.
Right.
I don't have a copy, but I could provide it if
That'd be very kind.
you would.
Yes, please.
I should just, so you know, the New Zealand Court of Appeal did address this in respect of non-subsequent facts, so I should just show you what they said on this in Hyams and Peterson, which is
1012, possibly?
the judgment's relevant on 2 points. One, in respect of grounds 1 and 2 that we've been looking at, where, well, what happens is this. In May 1988, an investigating officer of the Department of Justice sends a memorandum to his supervisor concerning his investigation into the alleged fraudulent dealings of 29 named people, which included the claimant. And the alleged fraudsters became known in the media as the Gang of 20. It was alleged that the memo was circulated to various MPs and journalists. On the 7th of June, the leader of the opposition releases the memo to the media with the names redacted, and the day after it was tabled unexpurgated in Parliament, which resulted in widespread publicity. And the defendants applied to strike out the statement of case insofar as those words refer to the defendant. And the court addresses at 655 Baltinos.
What do you mean by 655?
1019.
Yeah.
And at 656, let me just do this. The second argument, the one I've been dealing with, is whether a prior publication on a privileged occasion is capable of affording a link between an innocent publication and the plaintiff individually. And that comes at line 15 on 656, on 1020.
Yes.
And what is said is that the suggested new principle will place a limitation on the admissibility of extrinsic evidence for such purposes. As formulated by Mr. Matheson in his reply, it is that a prior publication on a privileged occasion is not capable of being used to afford a link between an innocent, that is to say non-actionable publication, and the plaintiff individually. But we're referring to a subsequent publication, but that's the point. This new principle is contended to be justified for social and policy reasons pertaining to freedom of speech and the right of the media to discuss public issues. The particular contention in the present case is in effect that because the public naming of the plaintiff as a member of the Gang of 20 was in reports enjoying qualified privilege of parliamentary proceedings enjoying absolute privilege, the plaintiff is debarred from showing by reference to those reports the readers of the later publication sued upon would reasonably have understood them to refer to. And they cite 2 cases and reject the argument on the basis at 45 that the law provides various relevant defences to the media qualified privilege, fair comment and justification. But it is said at 657 line 5 that there are strong arguments both ways. And we're not saying such should be the law and express no opinion on the issue. There are strong arguments both ways. And I submit it's particularly strong if what one is saying is the subsequent publication on a privileged occasion can be relied upon to afford a link between one article and a later one.
Yes?
And that's particularly so where the privileged article is not one which refers back or contains the same defamatory imputation as the earlier article. And the final point on Hyams is that it's 1991, and we moved a long way on media privileges and protection of freedom of speech since then, including in that jurisdiction and the United Kingdom and others, for public interest defences and such like, which didn't exist. So we have I would submit, a greater appreciation and understanding of the importance, particularly of reporting privileges, ensuring that there aren't too many restrictions placed upon them, because the situation in a kind of this case is it would be safer not to report upon the inquest at all.
I mean, you're saying this is just another factor. No, you're not saying it's a rule of law then.
No, I'm not.
It's not a rule of law under the Defamation Act. You're just saying this is another factor. It's exculpatory, and it happens to be privileged, and therefore policy reasons for not extending.
I'm saying that there are particular features of this case, which is that the subsequent facts, the identification of the police officers, which don't exist in the other line from Hayward onwards, are that the identification is taken from a privileged occasion.
I know you're saying that, but I mean, you're saying that this is just one of these factors which are reasons for not extending the Hayward principle beyond the narrow points that you've identified.
My Lord, yes. Or if it is extended, and it isn't easy to extend it by a matter of days or such like, that it shouldn't, any subsequent facts that may be relied upon shouldn't be facts that only exist because they take place on a privileged occasion, because they arise out of a privileged occasion.
But when you throw up your hands and say, perhaps it would have been better for us not to report this at all, chilling effect, Mr. Skerritt is going to say, you didn't have to name them in the report.
They're entitled to be named from the inquest. So even if
They're
we...
entitled to be. You didn't have to.
But this would lead on to the second limb of ground two.
Well, this
because
is the exculpatory point, isn't it?
Partly that point, but even if we as a newspaper had not named them, because it is an open court hearing, they are nameable. Their names come out as part of the open justice principle. So that's why some of the other cases might be important on this issue, because would we be held liable if we hadn't published the third and fourth articles where their names come out as a result of the open justice principle, because we'd published the first and second articles? And on the basis of cases such as Baltino's, potentially we're liable whether or not we had published the third and fourth articles. So the privilege point, I say, is important because the courts are very strong, rightly, on the importance of open justice, but it can lead, or potentially can lead, to a situation where a newspaper, having published something in the past, finds itself liable many months later.
But if the newspaper in its first article, in this case Article 1B, let's call it the editorial, actually says, watch for the inquest, isn't it going to be set against you? This is one of those cases where the first article, if you like, gives the clue and lights the touch paper, because then a diligent reader will watch for the inquest and will know who they're intending to speak about once the inquest, as it's likely to do, because of the open justice principle, reveals the identity of the policeman concerned.
I don't accept, my lord, that the watch for the inquest it matters for this reason, that if the police are going to shoot members of the public, there is going to be an inquest,
Yeah.
regardless of what is written. So inevitably, that it would be implicit, even if it was stated expressly, that there is going to be an investigation into this. They're calling for an investigation throughout, and so are families. So even the Court of Appeal judge refers to that sentence, starting her sentence with the word incidentally, because it's not enough of a pointer to the defamatory imputations in the first and second article. Of course, it's a pointer to the fact that there have been shootings, and because there have been shootings by the police of members of the public, there will be an inquest.
But doesn't that answer take you slightly out of the frying pan into the fire, in the sense that if when you write your article, your first article, and you deliberately don't name the policeman, but it's about an incident which any responsible journalist would appreciate, even if he wasn't screaming for it, was going to lead to an inquest in which the policemen concerned would have their identities revealed, then isn't the first article in saying 4 policemen and describing the incident couched in a way that will make them identifiable in due course?
If they take care not to name in those articles when they're describing the incident, as they do, then that is a relevant factor as to whether they have, how strong any public interest defence would be. If the answer to that is, it makes no difference whether you name them or not, because the names are coming out anyway, then that does end up chilling at the beginning, because instead of taking a responsible line, which is to say, this is a matter of public interest, this is something that needs to be reported, but we will not name the individuals, you have a stronger argument on a public interest defence in those circumstances than you might have if you name. And I cited in the case the Strasbourg decision of Pedersen and Denmark on that basis, that paragraph 34 of the bundle on 0779, that one of the factors to be considered in a public interest defence, responsible journalism defence, is whether the publisher has acted responsibly, is whether it named an individual. But if the answer to that is, it doesn't matter whether you named the individual or not, because the name is coming out anyway,
But you lost on responsible journalism, and that's not subject to appeals.
we lost on the responsible journalism in this case.
Yes.
It was accepted that the story was in the public interest, but the journalist who wrote the story about the Special Branch report was no longer a defendant, didn't appear, and the Special Branch report wasn't produced, so we lost. So in terms of the journalism as identified at trial, we lost on that point.
But that related to the first articles, not to the inquest.
It was only the first and second articles that were the claim for damages.
You didn't lose, no one said you weren't being responsible in relation to the second.
No.
Correct, but my lord, if we are being responsible in respect of the third and fourth by reporting faithfully on an inquest, is it just to extract from those privileged reports the names and refer back to the earlier articles? And that's where I submit that wouldn't be fair, and turning the argument around the other way, but you would inevitably know whether you named it or not that they would be named. That would weaken a responsible journalism public interest defence, where one of the criteria is how careful are you being with how you present the information, not naming people.
So you've dealt with the privilege point. Have you also, in effect, covered the exculpatory point?
In essence, in that the third and particularly the fourth article are vindicatory of the claimants, and therefore it shouldn't be right to ignore the antidote in those articles and just focus upon the names and remove the names from their surrounding context and put them into a different article 6 to 7 months earlier. And indeed, there's no evidence at trial called by the claimant about which of the two articles, June or July, made the difference, and whether anyone identified them or completed the cause of action between those 4 articles. So on that point, yes, my lord. Which just takes me to the last ground, which is ground 3.
Quite.
Did you, in paragraph 48 of your case, you referred to textbooks, including Gatley, which I think you have a part in, but I couldn't find them in the bundle.
I'm sorry, my lord. I believe Gatley is in there, but
There is an extract from Gatley, but not the one to which you refer.
then I will provide them.
I mean, basic, but they don't help. They just say it's all very difficult, which is what everyone seems to say about it. So,
But both the textbooks.
but they do seem to say that the Grappelli principle is still sort of the starting point, anyway.
My lord, they do, and the Court of Appeal did in Le Chaux,
Yeah.
and my understanding is
And
the Supreme Court
did too.
did in Le Chaux as well.
All right, well, I've got that. But yes, I mean, it would be helpful to have the extracts from...
Though not with the Grappelli-Hayward problem, I think, at all in mind.
Not looking at it, no.
No.
So, ground 3, Mr. Speaker.
Ground 3 is that the Court of Appeal wrongly held that the trial judge should have admitted evidence from the claimants that had not been pleaded, that they had been identified as at the dates of the first 2 articles. So in essence, the argument we've been addressing all morning didn't or shouldn't
Indeed.
have mattered. The starting point on this is the pleading, which is at 008. Just so this is in context, at 0013, the prayer identifies that the claim in damages is for damages for libel in respect of the 2 first and second article, the 2nd and 3rd of December article.
Yeah.
And there is a bare assertion at paragraph 10 that they were identified by name and the words were understood to refer to the claimant. But there are no particulars that anyone did identify any of the 9 individuals from the 1st and 2nd articles.
But so it's, you're complaining about the Court of Appeal's admission or rejection of the judge's refusal to admit evidence of a pleaded but unparticularised allegation.
Yes, what happens is, I say, that in order to lead evidence at trial, that they were identified from the 2nd and 3rd of December articles. That case had to be particularised, had to be pleaded, particularised and led. It wasn't pleaded. The first
It was pleaded, but it wasn't particularised.
Sorry?
It was pleaded, surely.
But it wasn't particularised.
Yeah.
Let me take you to where it has to be particularised.
Yeah.
Which is in the Morgan case, for Bruce and Oddams and Morgan, 1109.
1109.
1109. This was the Court of Appeal decision. This is the common law position. It's now established in all of the civil procedure rules. So in England and Wales, in Part 53, in Trinidad, I will find it at some point. But the fact that you have to plead extrinsic facts on innuendos is now in the civil procedure rules. But the case here involved the plaintiff bringing an action in which she alleged that the words "an English woman, she and her" referred to her as an individual guilty of plane smuggling. And the court held that the material facts on which the plaintiff must rely in a libel action necessarily include the facts and matters from which it is to be inferred that the words were published of the plaintiff. Without a statement of these facts, it's impossible for the defendants to be in a position to decide how to plead the statement of claim. And that's the principle.
But that was a case in which, as I understand it, an application for particulars has been made and not provided, and the master ordered that they should be provided.
Yes.
And that was upheld.
Yes.
Is that the same as saying that where you plead an allegation in very general terms, and nobody asks for particulars, you can't then call evidence to support the allegation?
My Lord,
it could be a very different situation.
It is now unequivocal and uncontroversial,
Okay,
because it exists in the civil procedure rules. But I'll show you what was said by the House of Lords in Morgan, which is at 1049. So this case starts at 1485.
Sorry,
1485. Volume 5.
Yes.
This was a case in respect of which the claimant was dog doping gang goes into hiding, and the issue is whether the plaintiff, who was not named, could be identified as part of the dog doping gang. And the point made by Lord Reid at 1489 answers, I hope, my Lord Briggs's question. It's 4 paragraphs down. It must often happen that a defamatory statement published at law does not identify any particular person, and that an ordinary member of the public who reads it in its context cannot tell who is referred to. But readers with special knowledge can and do read it as referring to a particular person. A number of matters are not in dispute in this case. It does not matter whether the publisher intended to refer to the plaintiff or not. It does not even matter whether he knew of the plaintiff's existence. That's been upheld post the Human Rights Act in the Court of Appeal. And it does not matter that he did not know or could not have known the facts which caused the reader with special knowledge to connect the statement with the plaintiff. Indeed, the damage done to the plaintiff by the publication may be of a kind which the publisher could not have foreseen. This may be out of line with the ordinary rule limiting damage to which a tortfeasor is liable, but that point does not arise in this case. On the other hand, when people come and say that they thought the plaintiff was referred to by a statement which did not identify anyone, there must be some protection for the defendant, who is thus taken unawares. It's now well settled that the plaintiff must give sufficient particulars of the special facts on which his or his witnesses rely. But that in itself may not be enough. It may be plain and obvious that no sensible person could, by reason of knowing those facts, jump to the conclusion that the defamatory words refer to the plaintiff.
Yes. I wonder whether, when we look at paragraph 10 and wonder whether that was good enough, and you say it wasn't, whether actually we should have looked at slightly more carefully at the way in which the claim form is cast, if you'd be prepared to go back to that, at the very beginning of volume 1, page 6 perhaps.
My Lord, yes.
Or statement of case, page 8. Paragraph 3 is the 2nd December publication. Paragraph 4 is the 3rd December editorial. Paragraph 5 is the July publication. Paragraph 6, rather curiously, goes back to the June, but no matter. And so it's all seamless. They're relying on June and July. So when you get to 10, I should have thought the reasonable inference is that the claimants were identified by name and all the words were understood to refer to the claimants, refer to all those publications and not just the first 2.
I was, stepping back a point, the claim is a claim for damages in respect of the first 2 publications.
Yes.
and we can see that from both the claim form and the prayer.
Quite.
I accept, and the point was the point was taken at first instance that it's not clear that they were relying upon the later articles in order to be identifiable in the earlier ones, and the courts dismissed that as an argument because on its face that's acceptable enough on the pleading that the subsequent facts relied upon to identify the individuals are the later articles. They're claiming damages in respect of the December publications in which they're not named. They are relying upon their case of reference by reference to the later articles.
Right.
And to that extent, that's sufficient, and I make no pleading point on that. That's a question of law. But the court goes further and asks and addresses the question as to whether they were identifiable as at the date of publication, that is to say, as at the 2nd or 3rd of December, because it would be reasonable to infer that some people would know who they were, absent the 2 later articles. And I say that that was not a finding that the Court of Appeal was entitled to make, because it wasn't a ground of appeal, but even if it was, the judge was correct in how he addressed it, which was it wasn't particularized, and it had to have been. They didn't identify anyone who did identify it, who did identify them. They didn't need any evidence of that kind.
I think the point being made, I may have misunderstood it, in relation to Lord Briggs's point, that they did plead it. In fact, when you look at the pleading, it's not at all clear that they were pleading anything about the 1st.
That is the point I was trying to make.
I apologise.
So I was surprised you weren't very happy with that.
It's always difficult to see a point in your favour. It's always difficult to spot.
Well, there we are. It may have merit, it may have no merit. Mr. Skerritt will have something to say about that.
I'm grateful for, but it is very clear that there is no one identified as having read the first 2 articles and identified the claimants from it. And I say that that is an important pleading requirement, and pleading is important in defamation cases. And the reason for that is explained partly by Lord Reid in Morgan, that one has to, it's one of those protections. If you are going to have an objective test for a claimant's reference on claimants, and if you're going to allow a claimant who's not named in an article to be able to recover damages for it, you have to have some protections in place and you have to be able to identify it, and that's not there. Mr. Justice Citation deals with this in his judgment at paragraphs 53 to 59. Three, 4, 6.
Oh, no, I've miskeyed it. Yeah.
At paragraph 53, 30365.
Yes.
And his lordship explains that the claimants advanced the argument that they did not need to be expressly named, since it was reasonable to conclude that members of the police service would identify them. And he goes on to dismiss that argument with reference to Bruce and Oddams and others. He says at 56, the statement of case is bereft of the requisite pleading details needed to establish this particular line of argument. The court also agrees with the defendants that the claimants did not plead any reference innuendo to enable them to lead any evidence of extrinsic facts to support such a plea. They didn't plead that anyone were aware that the officers who were involved, nor did they plead that anyone made a link between them and the first article and the editorial. He identifies that they sought to adduce evidence at trial, not in their witness statements, that they received unpleasant phone calls, that it was met by an objection, and as the trial judge, he ruled on the point. So, at the very beginning, I showed you the sub-issues that he identified at paragraph 39. This is the second sub-issue at paragraph 39. whether they were identifiable from material extrinsic facts other than the subsequent articles. And he provides reasons, and they are correct reasons, why that line wasn't open to the claimants. That wasn't a ground of appeal, that he was wrong on this. The grounds of appeal are at page 375 of volume 1.
Yes. Well, if you say it's not there,
I say it's
well,
not
that
there.
it isn't.
Yes. And there's a supplemental ground, to be fair, at 610, but it's not there either. Court of Appeal deals with this at 654.
The supplemental ground, it's in the same area, isn't it?
It is in a similar area, but it's not the point.
No.
She decides.
Ought to have addressed? Does that mean he was wrong to say it should have been pleaded? 610. 611, rather. The subsequent articles, it's not,
No,
it doesn't help, does it at all? It's all four grounds are subsequent article.
Yes.
My lady, yeah.
Yeah.
Yeah, thank you. Yes, okay, we got that.
Then
Nothing on the grounds.
So on to the judgment. 5.4. Paragraph starts at paragraph 40.
Which is not
Do you have to
654.
start at 39, actually? Because it's quite difficult to make sense of this passage, I think.
I'm sorry, I'm just jumping around because of the number.
Because you pick up in 39 the judge's view of pleadings and that they are just to let the publishers know the case they have to meet. And it's with that in your mind that you then go on to 40, isn't it?
My lady, absolutely. And as identified, the first judge at first instance picks up on the fact of the importance of pleadings and the particularisation, and he's right, and her ladyship disagrees. She then goes on to dismiss the argument that there wasn't a failure on the officers to plead or to lead evidence. And she appears to find that there was, notwithstanding the fact that his judgment is pretty clear that objection was raised and a ruling was made, that evidence was adduced and should have been relied upon to establish that the individuals were identified as at 2nd and 3rd of December 2008.
I'm sorry, I'm finding it difficult to follow this. 40 is the judge dealing with the connection between the subsequent articles and the first article in editorial. So that's not the point we're on at the moment, is it, Mr. Speaker?
No, but
Where does she deal with the point we're on at the moment?
she deals. I take it that from the next line of that, and then at paragraph 43. But you might find it's easier for her conclusion is at page 0057.
Oh dear, I'm in a different...
Paragraph 60, subparagraph 7, the issue of innuendo.
Well, that's her conclusion. Is there any paragraph making that point?
Yeah.
Prior to 67?
It's at 43, but she seems to think that innuendo is only relevant to the question whether the article is defamatory, and innuendo has got nothing whatsoever to do with identifying the targets of the article.
And, my lord, she's wrong.
And you say she's wrong about
Yes.
that? Yeah.
I say that these days one refers to the meaning innuendos and reference innuendos. And if it is a reference innuendo, because the claimant is not named in the publication, you have to plead the particulars of special facts that would lead the reasonable person, reasonably acquainted with the claimant, to understand them from the article. And therefore, when she talks about, her ladyship talks about extrinsic evidence and seems to confine that to meaning, that's incorrect.
But in paragraph 43, is she dealing with two separate things? Because at the beginning of it, she's talking about a strict case of the plain ordinary meaning of the words used and whether there's a bridge between the first article and the subsequent articles. And then she says the judge was wrong not to allow them to adduce evidence about the morning of the first publication, which would have completed the cause of action without any reference to the second set of material, wouldn't it?
And she appears to find that to be an error of the judge, because one takes that from 60.7, plainly wrong not to allow the officers to adduce evidence that on the morning of the publication of the first article.
But it's not related to the first part of paragraph 43.
It says the trial judge was therefore plainly wrong.
Yeah.
So you say there's a non sequitur there.
Yes.
My lord, yes. I say that any conclusion that the cause of action has been completed on the 2nd or 3rd of October December is simply wrong. And however her ladyship has got here, it doesn't follow, and it shouldn't have been allowed because it wasn't pleaded, wasn't particularised. Whatever evidence comes out was objected to. The judge ruled upon it, and it wasn't challenged on appeal.
Might it be a slightly simpler point that what she purports to use as the justification, the judge was therefore plainly wrong, doesn't relate to the point that it's a justification for?
Yes.
I think.
Well, there we are. That's ground 3, isn't it, Mr. Speaker?
My lord, yes. Just on that point, if I may, I've raised various errors here, but there is a suggestion in paragraph 43 that the publishers cannot escape liability through the ruse of split articles.
Well, you don't like that phrase, and you don't know why it's been deployed, because there was nothing in the evidence to suggest that there was a deliberate design as between December and June.
And intention is irrelevant.
Yes.
So the publisher's intention here appears to have been taken into account by the judge, who has already acknowledged earlier on in paragraph 31 that her ladyship agrees with Bradley that proof of intention is irrelevant, but it appears to be at paragraph 43 that she is relying upon subjective intention of the publishers to find that all 4 articles were a ruse, a split article. So therefore, for that reason, I say that on ground 3 simply wasn't open to her ladyship and the Court of Appeal to complete the cause of action as at the 2nd and 3rd of December, and as at grounds 1 and 2, it wasn't open to them to rely upon subsequent articles. I have to deal with my Lord Carnwath's point as to what the right answer would be. I have tried to address the points in the case. That's paragraph 96 on page 0795. From the authorities, if one can establish a principled basis for departing from Grappelli, it would be rare. The primary feature is same defendant, and one can see why one could hold a defendant liable for publishing a later article going backwards because it was responsible for the first one. But the courts there does have to be, I would submit, a very strong connection between them, as there was in, say, in the Bradley case, not simply that they are the same subject matter as something here. So a clear link was identified in Hayward, not only because they were both about the Scott affair, but they were in fact both about whether or not there was going to be a police investigation into Mr. Hayward's providing money to the Liberal Party and whether he was complicit in the conspiracy. So I would, to take that as an example, I wouldn't submit that the Scott affair itself was sufficient, but the articles in Hayward were more specific about the particular involvement of Mr. Hayward in the alleged and found to be untrue conspiracy to murder Mr. Scott. So that's much narrower. But those are, as I identify, the features that arise from the cases. Same defendant, a very clear or strong link between the subject matter of them. There is then the time gap, which I recognise Lady Arden not keen on, but it may well be that if it is the same day, very closely connected in time, it's a more justifiable reason for inferring, for instance, that they were intending to go for the defendant and intending to light the fuse, than if there is a very long time limit. So whilst I fully appreciate that a particular point in time is arbitrary, it is more natural that the closer in time, if the justification for the reliance upon the subsequent publication is an imputed inference, intention to identify him, the closer you do that, the more it's likely to lead to that.
Well, thank you for bringing those points together. We'll have to consider them carefully. Is that about it, Mr. Speaker?
My Lord, it is.
Well, that's good timing. And although I think you had half an hour this afternoon, you're not going to be using it.
I'm not.
Well, that's fine. Mr. Skerritt, then, will it be acceptable for you to address us at 2 o'clock?
Yes.
Perfect.